Trudy Mason sitting in for Elias Makos again this week. And this segment, we are talking about the man who became known as the Maxi store killer. This was an individual named Randy Shalumba, walked into a Maxi store and stabbed a woman 14 times, killing her. That was in 2016. The woman named Clémence Beaulieu-Patry. Randy Shalumba had appealed his first conviction in this case, arguing that he was not criminally responsible for the murder because of mental illness. And the Quebec Court of Appeal did overturn that first conviction and send the case back for a second trial. It is in this second trial now that the courts have again concluded he is guilty of first-degree murder. Helping us to unpack the details in this case, criminal defense lawyer and legal analyst Ari Goldkind. Ari, welcome back to CJD.
Good to be with you.
Your first thoughts on the outcome of this second trial?
So it's really a shame because you go back to brass tacks. This person murdered a young lady and seems to have the benefit of hundreds and hundreds of thousands of taxpayer dollars, courtroom benefits. Goes back to 2016, if my memory serves. Imagine being the family of this young woman butchered and slaughtered by what is arguably a monster or an extraordinarily mentally ill man. And here we are talking about it, July 2024. But this is something I comment a lot in my role as a legal commentator, which is over and over and over. We see jury convictions or acquittals, but often convictions screwed up and reversed. And I use the term screwed up purposely, because the only way you can almost overturn a jury verdict is by showing that the judge's instructions, and this is key, is by showing that the judge's instructions were unfair. And for people who don't live and breathe in the courtroom, at the end of a jury trial, the lawyers make their closing. That's the part all of us know from TV, your favorite HBO, Netflix, your favorite movie, A Few Good Men, everybody pictures the lawyers standing up and giving their impassioned speeches. That's not what gets the case overturned. Once the lawyers are done, a judge takes over for about a day to a day and a half on serious charges like murder and talks to the jury about what their role is, what the law is, what the facts were, what the evidence was. So the long and the short of it in this case, in the Quebec Court of Appeal, are very stinging in their criticism of the trial judge, is that the trial judge made two gigantic errors. One, on an area of what's called post-offense conduct, or what the accused did after the murder happens, vis-a-vis his steps he takes, how he acts, his mental illness, but also very sharply criticized the trial judge for an unnecessarily exhaustive, far too long jury instruction that also recited the evidence back to the jury that didn't need to be done because, as you know, jurors listen intently. It's their job to listen to the evidence. It's not the job of a trial judge to regurgitate it back to them.
Well, that's quite an indictment of the way the system worked, I must say.
Or didn't work.
Or didn't work. Yeah, I guess that's probably more accurate. Did the whole criminal responsibility or irresponsibility due to mental illness complicate this case? Were there any shadings in there that caught your eye?
It really did. So you add in mental illness, which is now being used, almost like ketchup spread on everything. And I think, the courts have to keep a very, very jaundiced eye on that being overused. Obviously, we have mental health issues and problems in Canada, but when everything is smeared with ketchup, nothing stays the same. Where the Court of Appeal found that the judge erred is gave really conflicting instruction to the jury that would have left them very confused on what are called the elements of the offense, how you get to first-degree murder or how you get to second-degree murder. Can you use his mental illness when it comes to post-offense or after the homicide conduct? Can you use it on your left hand? But when it comes to the right hand, there was a conflicting instruction to the jury about how to use that. So, again, just for people who want to know how the sausage is made in this, the jury instruction, or what's called the jury charge, is critical. And I say it all the time, both in my own cases and cases I comment on. We don't need to have these jury instructions be 400 pages. Juries are smart. They have common sense. We tell them to use their common sense. And when you have judges, in my view, making it unnecessarily complicated, 2 days of talking at a jury when they've just listened to things fresh, that is where defense lawyers like me pounce on a jury instruction to get a verdict overturned. And in my view, it's all completely avoidable.
Having looked at the details of this case, despite that overcharge, you could almost say, by the judge, in your view, do you think the jury arrived at the correct decision?
1,000,000%. And that's why I go back to, you just look at the common sense of juries. They tend to get it right. Even when they let a guy off who may have done it or you think have done it, there'll be something in the evidence that didn't sit right with them. They have a gut feeling. This is one of the reasons lawyers like me, and there are others like me and others not like me, who, given the choice between a jury and a judge, a lot of the times will say, I think I want 12 ordinary, average people off the street. And if I can't convince one of the 12, remember, I don't have to convince 12. I only have to convince one. A jury has to be unanimous for the time being in Canada. If I can't convince one ordinary, average Joe or Jill or Jane off the street that there's a doubt that my client did it, well, maybe my client did it. And here you have two juries that came back, I think, with completely solid verdicts. And again, the Quebec Court of Appeal does not criticize the jury. They almost never do criticize the jury. It all comes back to what are called the jury instructions, the jury charge, and it's a very sad thing. And I know we're low on time, but I'll tell you why it's very sad. You and I are talking about this in a 9-minute or 6-minute segment. But if people understood the man and woman power, the hours, the hundreds of thousands of dollars, the amount of stress on a family or an accused family or a victim family, these trials last 6 months, sometimes 4 months, sometimes 3 months. To have them sent back for a redo when the jury ostensibly got it right, but the instructions were just way too long and way too complicated, to me, given all the money your listeners waste on taxes, nobody ever thinks about just how much money and time and emotion is wasted on sending these things back. And good for the Court of Appeal for having a problem with it and doing what they thought was right to do.
Ari Goldkind, thanks for joining us.
Always good to be with you.
Ari Goldkind, criminal defense lawyer and legal analyst. By the way, Randy Shalumba, 25 years behind bars with no possibility of parole. The family, the parents of that 20-year-old woman who was slaughtered at the Maxi are saying they were overjoyed at the conclusion of the second trial, and they say the verdict gives them some peace knowing that the guilty party will not be able to apply for parole until 2049.